Thank you very much, Eduardo. I hope you can hear me
Yes.
and probably see me also. Thank you. Well, dear colleagues, ladies and gentlemen, good afternoon. Let me first address, of course, my thanks to the organizers of this online conference for inviting me, and in particular, I owe my gratitude to Eduardo, my colleague at Louvain. On Tuesday this week, and because this is a very special academic year, on Tuesday we had together a special gathering with the students in order to explain them the new teaching modalities put in place due to COVID-19. And this gave me the opportunity to see Eduardo delivering the most enticing introduction to tax law. Had I been a student now, maybe I would have developed a very special interest for tax law thanks to Eduardo. But I was a student 30 years ago. So I must confess, as Eduardo just pointed out, I must confess that tax law is not my turf. And maybe by the end of this presentation, you will confirm that tax law is not my turf at all. But this makes your invitation all the more interesting, that is challenging for me. I'm discovering incredibly interesting debates that tie very nicely with some very basic and yet unresolved issues in public international law. And by way of commenting on Philippe's excellent paper and presentation, I would therefore like to first quickly go back on those basic issues, and two, offer my very general views on a possible alternative framing within general public international law of the very questions that brings us together. So let's go back to basics first. Everybody recalls the Lotus case, decided in 1927 by the Permanent Court of International Justice, where the court affirmed that while a state had primarily a territorial sovereignty and could not exercise its powers on the territory of another state without the latter consent, each state was, however, free, I quote, to extend the application of its laws and the jurisdiction of its courts to persons, property, and acts outside its territory, end of quote, unless and until there existed a specific rule binding that state which forbids it to do so. And the court said that, I quote again, under international law as it stands at present, there was no general rule prohibiting states to legislate with extraterritorial effects. International law, in other words, is a permissive legal order where states are free to act as they please as long as a rule binding on them does not limit such freedom. So such basic conception refuses to consider international law as a legal order that allocates authority between states. States are sovereign, they derive their authority, power, capacity, jurisdiction, you name it. They derive all those things from themselves. They are not entrusted with such authority, power, capacity, jurisdiction by international law. They do not need to justify such authority, power, capacity, or jurisdiction on the basis of any rule of international law. And as I just recalled, the PCIJ carefully introduced a caveat in the judgment, making clear that such was the principle under international law as it stands at present. Ladies and gentlemen, exactly 93 years and 10 days later, has there been any change in the basic structure of international law? The short answer is not really. But let me quickly bring you through two cases that show how much the oscillation that President Max Huber, the president of the PCIJ at the time, and whose casting vote was needed to have the Lotus case resolved as it was resolved, how that oscillation continues up to this day. And the first case I would like to bring to your attention is the arrest warrant case, a case decided in February 2002 by the International Court of Justice. The case concerned the issuance by Belgium of an international arrest warrant against the then acting Foreign Affairs Minister of Belgium's former colony, the DRC, the Democratic Republic of the Congo. At the time of the arrest, at the time that the arrest warrant was issued, Belgium had a very broad universal jurisdiction. The statute was extremely broad, with no connecting factor whatsoever. Belgian courts were competent in case of genocide, crimes against humanity, and war crimes without any connecting factor. Not even the presence of the alleged perpetrator on Belgian territory was needed. And this went much further than Belgium's obligations under treaties to arrest and prosecute any person found on its territory, even if the crime were committed abroad by foreigners against foreign victims. I was counsel to the DRC in that case, and in the written submissions, I argued that unfettered universal jurisdiction was contrary to the very notion of universal jurisdiction, and also contrary to international law itself, because international law had changed since 1927, and that Belgium was incapable of providing a legal ground under international law for its own domestic statute. However, that was a very difficult argument to make, precisely because under the Lotus principle, Belgium ought not to prove that it was entitled by rule of international law to have such a broad universal jurisdiction without any connecting factors. On the contrary, it was for the DRC to establish, under the Lotus principle, that what Belgium did was in contravention with one of its international obligations. But no such obligation really existed. Therefore, our draft final submissions were phrased in a very careful way. We argued that, I quote, the exercise of universal jurisdiction without any connecting factor had no basis in international law. But even such a tuned-down allegation of breach was finally dropped for all sorts of reasons that I don't need to develop here. But let me just recall that the DRC was at war with its neighbors, that the Foreign Affairs Minister was prevented from traveling abroad to negotiate peace, and that the issue was actually very difficult, legally speaking, because precisely of the Lotus precedent. And we wanted a quick judgment from the court with a lot of authority, trying not to have a divided court, but having a court with a very strong majority. Therefore, at the end of the day, the DRC limited its claim to the violation of the customary rule providing for the total immunity from criminal jurisdiction of the acting Foreign Affairs Minister. And the DRC won the case 13 votes to 3. And of course, a claim of immunity can only occur, logically speaking, before a competent domestic court. That is the logical sequence of events. It is only if there is jurisdiction that immunity may be an issue as a bar to jurisdiction. And finally, we did not argue jurisdiction, therefore the court remained silent on the issue of jurisdiction and only addressed the issue of immunity. However, the court referred in an obiter dictum to certain situations in which immunity would not bar the exercise of jurisdiction. And while doing so, the court seemed to subordinate the existence, and not only the exercise, but the existence of jurisdiction to international law. Indeed, at paragraph 61 of the judgment, it ruled that, I quote, provided that it has jurisdiction under international law, a domestic court could institute proceedings against a former Foreign Affairs Minister, provided that it has jurisdiction under international law. Those few words might be interpreted as a way to overturn the Lotus finding. However, this is not discussed in the judgment, and you will not find any reference to the Lotus case in the judgment of the court. In a more recent decision, of the ICJ, the Lotus conception of international law has implicitly been revived. The court was asked by the UN General Assembly to rule on whether the Declaration of Independence with respect of Kosovo was, I quote, in accordance with international law. I'll spare you the details of the court's reasoning, but suffice it to say that the court understood in accordance with international law as simply meaning is it in conformity with international law or not, which in turn would necessarily be the case, it would be in conformity with international law, said the court, in the absence of a rule prohibiting such declaration of independence. In other words, the court framed the question not in terms of entitlement of a possible right to secede, but in terms of the existence of a prohibitive rule against declarations of independence. And as the court said, it is indeed entirely possible, I quote the court, it is entirely possible for a particular act not to be in violation of international law without necessarily constituting the exercise of a right conferred by international law. And this way of phrasing an issue of conformity with international law is, in my opinion, very much reminiscent of the Lotus ontology. And so it seems that we've gone full circle, and we still need to work on the assumption that absent a prohibitive rule, states are free to do as they please. And I note in that regard that Philip's argument, which largely draws from Stefan Gaggio's paper, is in line with the Lotus underlying conception, because it affirms that under customary international law, states are bound to tax with a nexus or with an adequate nexus. It actually builds such requirement of a nexus as a prohibition to tax without any nexus, or to tax without an adequate nexus. In other words, the issue boils down to a source question under international law. Is there or not a rule of international law that contains a negative obligation not to tax without a nexus or without an adequate nexus? I'm not going to discuss the existence of such rule as a matter of customary international law, but I just note that even if it exists, it might well simply postpone debates on the very notion of adequacy, as Philippe just showed us. This is because even admitting that it is customarily prohibited to tax without any nexus, such obligation does not tell us much on what is an adequate nexus. In that regard, only a multilateral treaty might bring legal certainty, as general practice and opinio juris, the two constitutive elements of custom, appear rather limited when it comes to filling up the categories and the types of taxes listed by Philip. I personally doubt that one could come up with converging adequacy criteria through a comparative law exercise, and it would be quite a stretch to derive from any such particular convergence a specific international law rule, either conceived as a general principle of law or in terms of customary international law. Except, of course, in obvious and uncontroversial instances, which again would not be much helpful. This being said, and let me turn now to the second part of my argument, this being said, this relative skepticism, my relative skepticism concerning the existence and precise content of a rule or several rules of customary international law in that regard, does not mean that I share the view of those who consider that states are taxing in a complete international law vacuum. The complete vacuum theory is, in my opinion, untenable, even under the Lotus approach. And this is because such approach has not done away with two essential regulatory principles under international law. The first such principle relates to the prohibition of the abuse of right as a general principle of law within the meaning of Article 38, paragraph C of the Statute of the ICJ. Article 38 lists the various sources of international law that the court may apply in order to settle disputes. Under international law, abuse of rights refers to a state exercising a right either in a way which impedes the enjoyment by other states of their own rights, or, and this is the détournement prohibition, or for an end different from that for which the right was created, to the injury of another state. And sometimes treaties refer explicitly to the prohibition to exercise rights in an abusive way. For instance, Article 300 of the United Nations Convention on the Law of the Sea, that provides that all the rights and obligations under the convention should not be used in an abusive way. And also you can find international law pronouncements, case law pronouncements on the abuse of right. And probably the clearest case law in that regard comes from the WTO appellate body in the Shrimps case. The prohibition of abuse of right is correlative to the good faith requirement that in international law is commanding both the creation and the performance of obligations. So the Lotus freedom to act in the absence of a prohibitive rule was always open to criticism, because the inherent limit to the freedom of any state is the freedom of every other state. In that sense, the freedom to act can be considered as a right to act, and like any right, its exercise may not be abused. In the tax realm, it would be abused if it is exercised in a way that excessively impedes the possibility for other states to exercise, for another state to exercise its own right to tax. And I note in that regard that in her chapter on the genuine link requirement, Advocate General Cocotte appears to embrace an abuse of right approach when she writes that, I quote, states must not abuse their tax jurisdiction by regulating situations with no genuine connection to their territory. The second regulatory principle of international law that always looms large over the interaction between states is the prohibition to intervene in domestic affairs. The principle is enshrined in numerous United Nations General Assembly resolutions, notably the Declaration on the Principles of International Law concerning friendly relations between states, and the International Court of Justice affirmed the customary international law character of the principle of non-intervention in domestic affairs in the famous Nicaragua case in 1986. What is interesting with the non-intervention principle is that it allows to consider illegal a behavior that is not intrinsically per se illegal, but that becomes illegal because of its intervening purpose. Therefore, even assuming a freedom to tax without a nexus, the exercise of such freedom might still amount to a breach. And what is interesting with that principle is that it actually, in the tax realm, it actually works both ways. A state may object to the imposition of a foreign tax because it interferes with its domestic affairs, but a taxing state may also use that principle to resist allegations that it should not tax a foreign taxpayer that has significant domestic activities. Of course, and this is the downside of the argument, endless debates can exist about what constitutes domestic affairs in relation to the taxation of persons, activities, or revenues that have a transnational aspect. Be that as it may, those two regulatory principles converge in that they both assume that in the allocation of any possible tax revenue, certain states are more entitled than others, which is just another way to look at the adequate nexus requirement. Unfortunately, like the adequate nexus requirement, those two principles remain rather vague in terms of entitlement priorities, which would help resolving tax claims conflicts. However, this alternative approach squarely frames the issue in terms of international responsibility of one state vis-à-vis another state for wrongful conduct. The issue is not so much the inopposability of a foreign tax to a taxpayer for lack of nexus, but the possible wrongful deprivation of a potential tax revenue by one state to the detriment of another state. In other words, let me submit that looking at the issue through those two regulatory principles might usefully bring us back to its profoundly public dimension. After all, tax law is public law. I have not done a lot of tax law, but I hope I did got that principle right. It is public law. Trying to design a system of conflict of nexuses in somehow the same way as we have conflict of laws and jurisdiction in private law matters might prove inadequate or impossible if we lose sight of the public choice dimension of any interstate interaction in that regard. And that is why I think the multilateral tax negotiations are so difficult. But that is also why those negotiations are the only international law way forward. Thank you very much for your attention.
Thank you very much, Pierre. Very interesting. So I take my privilege as a chair first to open the discussion for 10 minutes because there are so many issues that have been touched. And second, to ask Pierre a question, because from what I understood in international law, there is no basis for justifying a specific nexus between nexus or jurisdiction to tax from one single state, but they could be under the doctrine of abuse uh, um, an element to help to solve an issue of concurrent jurisdiction between states, provided that it is established that one state has an abusive claim to tax. And that's what you said. Uh, I was wondering in to what extent the impact of those two concurring taxing claims on a taxpayer could play a role in, as you said, the public law relationship between both states, because that's quite clear, and it's very important that we keep that in mind. As tax lawyers, we always concentrate on the taxpayer, which is absolutely no part to the treaties or other norms of international law that apply between states. But could the fact that this concurring jurisdiction has an extremely damaging impact on a single taxpayer or a multitude of taxpayers play a role in the potential assessment of an abuse by one state?
Shall I answer now, Eduardo, or
Yes,
will
yes,
you
yes, yes.
collect several
Yeah,
questions?
yeah.
Okay,
No,
I'll go
I
first now.
can't wait.
You can't wait. Well, obviously, I don't have a clear and final answer to your question. What is interesting, I think, is indeed that, and maybe I'm wrong on this, but I have the impression that the questions that we are addressing so far have been very much seen from the point of view of the taxpayer. It is the taxpayer that bears the burden of those conflicts. And so there's a kind of human rights approach to all this. I mean, the taxpayer itself should uh, maybe maybe it's because states are unable to get their act together and agree that indeed at the end of the line it is the taxpayer that suffers or that bears that burden. Now, of course, in public international law, if that occurs, it is always possible for a taxpayer to go to its own own national state, and provided that it really is genuinely the national of a state, that state, and provided that it has exhausted local remedies, the state of nationality can bring an interstate claim against the taxing state. And I would submit that the way such interstate claim, and that's also what brought me to think about those two principles, because I was trying to think about, well, if this translates into an interstate dispute, how will the dispute be framed by the claimant state? I guess in such a dispute, when a state endorses the claim of its national and claims that another state is taxing too heavily or wrongly, abusively, that state will have to play with those two governing principles that I set out. I am completely unable to tell you if this is a claim that could be successful or would be defeated by an international jurisdiction. And of course, very much depends on the facts. But if we have to imagine how such an, how the lot of a taxpayer could be translated into an interstate claim, yes, very likely those principles will be at play. I'm not saying that the taxpayer is entitled to rely on those principles, not any more than a citizen of a country may rely on the prohibition to use force between states. But that's also what I find very interesting. It's precisely this interplay between, and I think it is because the states have not managed to agree between themselves that claims by individuals are more likely to occur.
Thank you. We'll take 2 or 3 questions for this round. Please raise your virtual hand on the top right side of the screen if you'd like to intervene. Yes, Andrea Riccardi. No, wait. No, she's entering. Sorry. Who's raising his hand?
Pasquale is raising his hand. Rita
Pasquale.
is as well. And
Pasquale.
Yeah.
I can
Thanks
see.
very much, Juliane, Philippe, and Pierre, for your very interesting presentations. I would like to mention the case of with the financial transaction tax, UK versus Council of European Union, decided as inadmissible on 30 of April 2014. And I think that that is a good example of situations in which there may be a conflict between jurisdictions and taxing jurisdiction due to the fact that there are different goals pursued by the different countries. And clearly, on the one hand, one can say from the UK perspective that the exercise of the taxing jurisdiction was to some extent creating problems to the UK, which had possibly opted to be out of the enhanced cooperation. And this is just one of the many examples that we can bring in international tax. Here there is a clear action by one former member state, but the difficult thing is that we are overwhelmed by the different goals and priorities of the countries in exercising their taxing jurisdiction, which in fact create dramatic problems across the borders within the European Union, as I will say tomorrow.
Thank you, Pasquale. Other reactions?
Yes, I would like. I don't know. I don't have no clue where it looks where you have to push your button somewhere as a guest.
But it's okay. You can.
That's good.
Let's go.
Yeah, thank you very much for these brilliant presentations, everyone. I enjoyed very much these clear questions. It seems to me, and we're going to talk about it tomorrow, that at some point, what we call nexus is not defined. We take it for granted that it's a genuine link, that it is a way to allocate taxes. And I'll give you a hint of that tomorrow when I speak. But my question is actually to Pierre. And it's really a new beginner's question. Like, you are new beginners in tax, I'm a new beginner in public international law. But is it possible to bring a tax case, that one state would bring a tax case at the ECJ, at the International Court of Justice? Is it excluded from the scope, or does it have to be held by a clause compromissoire between states? How in practice would it work? I mean, could the US sue the European Union there for a tax that is extraterritorial? That's a very simple question for Pierre.
Shall I answer it now?
Yes.
Or, yeah. Well, the ICJ has a general jurisdiction in the sense that it is not a specialized court, so it can hear cases on basically anything that relates to international law. However, it only hears cases between states. So the US might not sue the European Union. Moreover, so ratione personae, the jurisdiction is limited to states. Moreover, it's a ratione voluntatis jurisdiction, in the sense that it is only because states consent that the subject matter of the dispute might be decided by the court, that the court has jurisdiction. And this can be done either by a compromis, a special agreement, when the dispute has arisen, or in a compromissory clause in a treaty in advance, or also with the mechanism of the optional clause, where a state declares in advance that it accepts the jurisdiction of the court for any dispute that might arise in the future vis-à-vis another state that accepts the same obligation. And of course, issue of jurisdiction, and the dispute must fall within the consent that is given by both states. So it is entirely possible that such a tax dispute might be brought to the ICJ. There were before the Permanent Court of International Justice, some of those cases actually related to tax matters, and some of those cases related to tax matter in relation to the dismantlement and the redesigning of the borders in Europe after the First World War. Yeah.
So you have no more recent case than the First World War.
I don't think that there was no tax case as such. There were cases relating to companies that were brought under diplomatic protection before the ICJ. Belgium brought a case against Spain about the Barcelona attraction, which was a Canadian company. There was a case between Italy and the United States in the late 80s. But again, those diplomatic protection cases, when a state endorses the claim of an individual, you have admissibility conditions, okay? Nationality, of course, and exhaustion of local remedies. But it's entirely possible. And what is also possible, but I think unlikely, is that the United Nations General Assembly can bring to the court, like it did for the Kosovo advisory opinion, it brings to the court a request for an advisory opinion on a certain issue of international law. Any question of international law can be put to the ICJ for advisory opinion. It's not binding, but of course it's the World Court. I'm not sure the court would feel very comfortable with your nexus question, but okay. They are wise, and they would certainly have to decide.
Thank you.
Anything can happen, yeah, thanks.
Thank you. We'll take 2 more questions, one from Joachim English and the other one from Rita Tsudoki. Joachim?
Well, thank you, Eduardo. I'm not sure whether anybody can see me, but I hope you can hear me at least.
Yeah, we can see you.
I would just like to comment, and that's related also to a question to Philip, that I think we should not put too much hope in hard customary international public law when it comes to delineating international tax claims, at least in our current direct tax debate. Because I think, as I think also Pierre has pointed out, there is a genuine link requirement, but pretty much can be a genuine link. So only if it's obviously irrational, I think, will it not be accepted as a genuine link. And this might be the case, like in maybe the issuance principle in financial transaction tax. I have this position, but in the direct tax debate, I think what is adequate or not is a question of policy rather than of customary international law. And to support this, I would also like to point out that 2 years ago, the American Law Institute gave out a forced restatement of the foreign relations law of the US, and where they stated that the question whether a claim to jurisdiction to prescribe is reasonable is not a matter of customary law, it's just a matter of comity, so it can be observed but need not be. And that relates to my question to Philip. Philip, you formulated quite a few criteria, which I think are all valid, but I assume that you propose this as policy guidance rather than understand them as, well, legal requirements for, assigning taxing rights. Thanks.
Philip?
You wanted to take one more question. I think you promised Rita.
Okay, I promise Rita, so you can think a bit more about the answer.
Well, I'll give you the answer, but let Rita speak.
Okay. Rita.
Yes, hello everyone, and thank you so much for the very interesting, intriguing starting session of the conference. I would have a question to Pierre as well, and the same disclaimer as Cecile, that I'm in the first place, I'm a tax lawyer and not an international lawyer. So it might be a bit naive question, or maybe you can correct me if I'm wrong. The question is that when you said that basically on the basis of the Lotus precedent, there is no requirement for, strictly speaking, no requirement under public international law for nexus for jurisdiction. But you could infer some limits to the exercise of jurisdiction on the basis of the principle of abuse and the principle of non-interference into domestic laws. Another principle which came to my mind, and I read about them in some international law sources, is the principle of good neighborliness. Does that exist? Does that have any authority in public international law? And could we use that as a limit to the exercise of jurisdiction which has no basis or no nexus at all?
Okay, who wants to start? Philip? Pierre? Philip.
Yeah, you go first, because I've spoken at length.
Really? But your question came first. Okay, good neighborliness. Yes, it's a principle. I mean, it's a principle that applies when dangerous activities are carried out on the territory of a state, and the state must exercise due diligence on its own territory in order to make sure that, for instance, a pollution does not reach the neighbor's territory. But as the word says, it is good neighborliness. So it's between neighbors, and usually it's a principle. I mean, so far it has been applied in situations where states are neighbors, and where on the territory of one state, one activity has injurious, harmful effects on the territory of another. And usually it goes together with territorial sovereignty. I mean, it requires states to exercise due diligence on their territory, not only to control their own activities, but also to control the activities of private actors, corporations, bandits, criminals. So that's the principle of good neighborliness. It does exist, but I don't really see how, because of the specific context in which it has been applied so far, it could be used in your and maybe, yeah, in your context of taxation. Yeah, maybe if you want to score by that principle, that you think thinking about one state offering the nationals of the neighboring state tax haven opportunities, for instance. That would be that would be maybe what you are thinking about, Peter.
Yes, that's exactly what I was thinking about, because I'm rather doing research on harmful tax competition.
Yeah.
And in that context, I came across that maybe this principle could be something to rely on, something that could be interpreted as a limit, that as long as the exercise of your tax sovereignty inflicts harm on the other state, you are not allowed to exercise.
And in that sense, it ties back to the abuse of right and deprivation of the tax resource.
Okay.
But it does not really, well, it has an injurious effect on the other state, but not on its own territory as such. But anyway, yeah.
Thank you, Pierre.
Interesting. Yeah, thank you.
Philip?
Well, very briefly, just going back to Pasquale's question, UK and Council, I can't really comment because I was actually myself counsel in that case for the UK. Had the matter gone ahead, it would have very much raised these questions of adequacy of nexus for the FTT. I can't comment on the public international law points, but Joachim's point, entirely policy. I don't think I mentioned customary international law at all. I don't find an argument of customary international law particularly helpful. The question, beyond going to the point that there has to be a nexus, I think it's then a policy question of what is an adequate nexus and how you resolve issues of conflicting nexus. The one point I would say where I disagree with you is on the fact that your suggestion that the only type of nexus that can be rejected is an irrational one. I don't think a test of reason can be used here. I think that there has to be a point that goes beyond merely irrationality to choose nexuses that are actually administratively workable, all the points that all the criteria that I set out. Thank you.
Okay, thank you. And the last concluding intervention by Juliane Cocotte. Juliane, are you there? She has.
Achim,
Yeah.
the American Law Institute's restatement fourth, and I think that this is usually a well-researched work and not purely American. I think they do good work, and they nevertheless they require a genuine a connection between the subject of the regulation and the state seeking to regulate. The genuine connection usually rests on a specific connection between the state and the subject being regulated. And then comes the usual nexus, territory, effects, active personality, perceived personality, or protection, and then universal jurisdiction with regard to universal crimes as trade in slaves and so forth. So there needs to be some nexus, but of course it's difficult to define. But I do not think that it's only the prevention of abuse. Yeah.
Thank you very much. Thank you to all the speakers. Sorry for the participants who weren't allowed to raise their question, but time flies. So it's my pleasure to close the first session, and we will resume in 13 minutes at 16:05 for the second session. Thank you very much.